document, regardless of how highly classified it may be and how it is stored, that would constitute a, quote, clearly erroneous jury instruction that entails a high probability of failure prosecution. The government must be provided with an opportunity to seek prompt appellate review. Prompt appellate review. What are Jack Smith's options, given the order and also the tone of Aileen Cannon today?
Yeah, that's the $65,000 question, right? And, you know, this has been so unique to Judge Cannon all along. She issues rulings that aren't really complete or definitive rulings, or what we call final orders that are appealable. And that's what she's really done here. She said, right now, at this point, based on the indictment, the PRA does not provide a reason to dismiss, leaving open, of course, what we've just been talking about. So I think right now there's not a final order for a traditional appeal. There is the prospect of seeking a writ of mandamus. And to do that, what you're doing is you're going to the Court of Appeals like you would on an appeal, but you don't have a final order to appeal. And you're saying that the judge made a clear and indisputable error. Here it would be not addressing the legal question that Jack Smith asked her to address, that there's no other alternative to obtain appeal, and that this kind of a order would be appropriate. Now, I think there's another option before going for a writ of mandamus. If I were Jack Smith, I would be thinking about filing a motion in limine, which is really, in limine is Latin for at the threshold. It means a preliminary motion that usually is filed to seek to preclude the admission of evidence or argument at trial. And it's ruled on before trial so that the jury won't be prejudiced by evidence that is introduced or argument, right? And so and there's an obligation under the federal rules of criminal procedure for a judge to rule on pretrial motions where the failure to rule would preclude appellate review. So if Jack Smith were to file a pretrial motion like that, a motion in limine, and she either refused to rule on it or ruled against him, he could at that point seek that mandamus. That's a theory I'm thinking that might be avoid some of the problems with there not being a final order.
Okay, what do you think of that?